20.20b. There's Gavin's notes there that with no escalation calculation required towards the end of his first paragraph, or his first sentence.
Hang on, I don't think the chair has got a different colour.
I've got a different version.
It's PC14 evidence.
Is it PC14 evidence or what we received as an updated brief?
No, it's 28 May 2025.
Yes, what paragraph? 20? Might be about 20.
20, subpara B. Look at the one we're holding.
Like the right one.
Yes, this is statement of evidence of Gavin Stanley dated 28 May 2025. Have the commission? That's what you've got.
I'm looking to the right place. Sorry. I do have it.
Well, yeah.
I do have it. There's an executive summary with them.
Okay. Okay.
On there. 20B.
So escalation has been. I said he hasn't. So replacement modern high-end multi-level house not changed due to this bit of investment based on extremely limited information with no escalation calculation required. So I've understood what that means. He hasn't applied it, but his workings show that he has applied it. Yeah. It's just a correction.
Apologies, my mistake.
Okay. So if you perhaps just want to answer any questions and then you can go away and read that 2-pager and see if there's anything else shouldn't. But we'll accept the questions.
I don't think. Christian? No.
Okay, so if you want to read that 2-pager and let me know if there's anything you want to. Donna, you can come up here.
Thank you for that. I dismissed you rather rapidly.
Update.
Yeah. Good.
Right. Now I have Mr. Shoulders. Mr. Shoulders did the evaluation evidence at PC14 and with a bit of luck that is attached to Mr. Pleasers and here's just an update for his evaluation.
I'm just drowning under. So the evidence contained.
The evidence, the PC14, you've actually just flipped open. It's attached to Mr. Pleasers, the original evidence for PC14. They were there right there. Paul Baker. That looks like Paul Baker there. I can, yeah.
That's fine.
Okay. So I think there's another newer document in that as well. I'll look at the last hearing.
Okay.
Well, that will be in the embedded PC14.
Okay.
Right. Sorry.
So we're getting hot off the press literally today, aren't we? Mark, where are we up to? Can you just take the commissioners, you don't have to read the whole thing out, but just take them through the documents dated the 16th of June and briefly describe what you've done there. You don't need to read it all out.
No, that's cool. So this dated the 16th of June 25. We've looked at three aspects of this property. Firstly, the underlying land value, if it was unencumbered by any pensions.
Yeah.
And I think from memory that's come up with a similar, I've updated it, but it's a similar sort of level to what it was a couple of years ago. There's been a significant change in that.
Can you give me a number for that?
So the number is between 8.55 million and 9.15, including GST.
So there's
Yeah, 8,550 to 9,150, including GST.
Yeah.
So that's the bare land value if you could buy it and do whatever you chose to do with it. It's too big a parcel for someone to feasibly build a big house on and imagine getting their money back in the Christchurch market. Because really that would $7 million house on top of that would be a $16 million property. We just haven't seen those in Christchurch. So the next part of it was to try and identify or explore whether there was an option to, if the house was repaired or replicated, what sort of value would come back from the end project. And when we analyse sales of any residential properties, we always split them into their underlying land, the added value of the house and the added value of the site improvements. So we've done the same process here to try and isolate how much people want to pay for a character house in good condition in our market. So look for the bigger ones that were sold recently.
On which
And
page are you on?
That's on page 4,
What's your table at the
the
top?
table at the top.
Update.
Yeah. So that's the net rate column, which is the right-hand column. It's basically how much a square metre someone wants to pay for a house over and above the value of the land, the site improvements on their site.
So a similar analysis was done as for radiation resistant on current market.
Yeah.
So is it the same properties? No, so it won't be the same.
No,
properties.
no, a fresh wave. And
So
these are properties that have sold since the last hearing. So we basically worked through that process just to see how much a square metre someone wants to pay for a nice character house. And the range there is pretty consistent across, what we've seen for the last while, which is a couple of $1,000 a metre to over $4,000 a square metre. And that depends on their size and their location, their condition.
Which ones of these ones do you see would be in a similar location?
The ones in Desmond Street that's a prime location in Pendleton. Harakiki Street isn't too far from being prime. Landover Road's good. The two Beverley Street ones are close to Mirabelle. They're in pretty good locations. Winchester Street's in Mirabelle. It's a good location. There's a couple of fringe ones there, which are the first one, Woodfields Road, and the second last one, Leaston Road, which
Where
are
are
both
they?
they're rural.
Okay.
Okay.
So we included those because they were protected and they were well presented.
Well, you mean heritage?
Heritage protected and they're well presented. And I've made a point in there that part of the issue with the protection is that if the protection on the house and surrounds is strangling the ability to use the land for what most people would do if it wasn't protected, the value of the house begins to suffer. Because it's basically holding back the prime land value of a developable site. The Leaston Road property is on 20 hectares in a zoning that's, it's on 10 hectares, sorry, in an area with a 20 hectare minimum subdivision requirement. So basically it's a really nice setting, nice house, and will stay as a nice house for indefinitely. It won't ever be subdivisible for 20 or 50 years. And the Woodfields one is out in the country as well, so there's a long way from that being a subdivisible plot. So they did add value to those properties because they were considering the ability to do something more valuable in the land. So we've included those because they were nice character homes.
What was the property that was sold or made the headlines recently? It was the guy's name escapes me out from Road Metals.
From
Road Metals, didn't he buy properties?
Murray.
Yeah.
Francis.
Anyone can write.
Yeah, that's right next to you, James.
Yeah.
Can you comment on that?
What's in the report?
Okay.
Yeah, what the summary, I think he refers to it.
No.
Yeah, didn't he at the very end?
I mentioned last time, but
Oh,
we talked about Wood Lane.
oh, maybe it's the Wood Lane one.
Yeah, no, that was Mr. Horncastle's or
Oh,
something.
you used it in the last report. Yeah.
Yeah, we're talking about Murray Francis as one in Pendleton Road. Yeah.
So basically we're looking at, how much does the house, whether it's either repaired or replicated, add to that parcel of land and on a per square metre basis. And I've turned that, it's 1,089 square metres of house. So I've concluded there that if it was repaired to the standard that it would have been in, I saw the property before the earthquakes and went through it. It was, it was in reasonable condition, but it was quite a tired old house. And we're looking there at an added value of the house sitting on the site of, a bit over $4 million. But what I was trying to explore there is if the repairs were done, we know the cost of the repairs from the QS evidence, would you be able to get your money back by pouring the money in that needs to be put in there to repair it? So if you've got a house that adds $4 million to the land value as a repaired house today, it's hard to justify spending $9 million or more to get it up to that level. And that's the crux of our argument. It's it's a very expensive project to repair. High value house finished.
Already?
1,089 rings about square metres. Pretty big house. Is that right, John?
Yeah.
So basically, there's a table on page 6, which just compares the end value of the house, which is the added value to the property, the $4,075,000, with the cost of repair, which both of the QS were about $9 million on it. So to do the project involves an overspend of 4.9 million or more to bring it up to a repaired state. So the last thing as I looked at is just whether there was any merit in replicating the house, and it's looking exactly as it does now, but rebuilt from the ground up. And since the earthquakes, there's been quite a few character houses replicated in good parts of town, and they generally don't go as well in the market as a modern sort of cutting edge design house. They don't sell as well, and they don't achieve the same amount of added value. And I put in there an example of a Wood Lane property, which is, a really nice location, 3,000 odd square metres of land, and quite a big modern replica house on it. And it sold for $8 million last year. And basically, if you dissect that sale into the land component and the site improvements in the house, it shows a value rate of about $3,600 a square metre for the house. So still a long way below the replication cost of a big character home. And that's our concern, is just the cost versus the return.
So worst case scenario is with totals.
$5 million. Yeah.
Mm.
Yeah. So those figures have changed marginally, probably in the last 2 years.
Yeah, no, I really go back and do that comparison.
Yeah. Well, I think the cost has gone up $1 million or something around numbers since last time, and the house value probably hasn't changed a lot. So.
Escalation around cost, but not value return. What were your figures done for PC14?
It was
Should know.
2023.
April.
Was it August or something?
August last year, was it?
At least in a year.
No, 2 years.
2023. Hearing was April last year. It was September,
Even.
2 years ago.
A lot before that.
Yeah.
So sorry.
2 years ago.
Yeah.
Mark evidence is September 23.
Yeah.
Good.
No, I'm happy if everyone else looks.
Yes.
Thank you.
Could you see if you can identify, we'll get your witness to identify the Murray Francis.
Yes. Yes. Do you know the
Is that the one
Pendleton Road?
that Richard died of?
Yes.
Yeah.
Yes.
Yeah.
Do you know the value?
I think it's sold for about $7 million.
Can you go and check can you check now while Jono's giving his evidence?
Yeah.
Yeah, you do that.
Yeah.
Yeah, it takes you longer than that, it's fine.
Yeah.
Yeah. No, that's all right. We'll move on.
That's not really an urgency, but it's easy to do.
I think they can do it if you just sit back there, and we'll carry on with Jono, and you can give us the number.
It was fundamentally a land sale.
Yeah.
Thank you. Thank you.
Okay, Mr. Cleese, who I'm very pleased to say was a witness who filed some minutes.
Can't be much shorter than your. It's no disrespect.
No good.
Just while we hands that out, just for context, we were, the reason why the evidence is a little bit sort of, timing's been of a little bit awry, is that we were hoping to get the decision from the minister on PC14 on Friday that would sort of put all this to bed. And obviously his sort of decision came out midday Friday saying he wasn't making a decision on Daresbury and Antonio. So we had sort of 3 or 4 hours to sort of talk the evidence with us.
Yeah.
So that's for why.
Appreciate that.
So there's just that dynamic going on a little bit.
Yeah.
So in my summary statement here, I've updated the numbers in it to reflect the evidence that you just heard on Gallagher and US.
Right,
So-
very grateful.
So they're updated numbers. Yeah, whilst there are a lot of numbers flying around with this one, but the fundamental message of repair being $5 million more than end value is the key number. So I'll maybe start read through it. So sort of 2.5 pages, but probably just if I read it through. So starting at 4, the district plan heritage provisions are a focused response to heritage management in a post-earthquake context. As such, the heritage objective, the policy on listing, and the policy on demolition all reflect the need to take into account damage and the reasonableness of the costs associated with repair and restoration. There remain a number of earthquake damaged heritage buildings in the city, and therefore, in my view, the recognition of such in the policy framework remains valid. At the heart of the debate on Daresbury is a test of whether the costs of repair are unreasonable. It's a triple brick multi-storey building that has experienced significant structural damage to the ground floor structure. The scope of works to rectify the damage is extensive. There is broad agreement between the engineering evidence of Mr. Gilmore, that's sort of PC14 and attached to my evidence here, for Daresbury, and the review of the engineering evidence by Mr. Hogg for council as to the scope of work. So there's no real debate about the extent of the works required to fix the building. There is likewise broad agreement as to the consequences of those works on the remaining heritage significance of the building between Mr. Pearson for Daresbury and Ms. O's and Mr. Fulton for council. And me paraphrasing, namely that the resultant outcome is largely a replica, that replicas are not generally considered to be an acceptable heritage outcome, the allowance of the significant earthquake damage necessarily tempers what would normally be an unacceptable outcome, that the heritage value of the resultant building is diminished, but that sufficient heritage value would still remain to warrant listing purely in terms of heritage values. Identification of heritage value is, however, the start and not the end of a Section 32 assessment of costs, benefits, efficiency and effectiveness. To pass the Section 32 test, a tool of listing needs to be assessed against the policy outcomes that that listing tool implements. This necessarily requires a robust consideration of the policy framework for both listing and demolition. The test for listing is set out in Policy 3.221, C1 and 2. To be listed, a building must first contain sufficient heritage value to warrant listing, and then there's an important caveat, unless any of the tests in clause 1 and 2 are met, and I list them out there, but in essence, it comes down to the physical condition of the building, whether there are engineering factors that would prevent its repair, and whether there are financial factors that would make it unreasonable to schedule the heritage building. So it's 3 tests there, the physical condition, the engineering, and the finance. And whether those repair works would be so significant that they would compromise the values to the point that it's no longer warranted to be listed. Ms. O's draws on the evidence of Mr. Fulton and assesses the first of the listing tests, namely whether or not the building, once repaired, would retain sufficient heritage value to warrant listing. She likewise draws on the engineering evidence of Mr. Hogg that a repair solution, albeit extensive, is available to pass the second test. She then, so there's no debate, I don't think, that the first 2 tests are met. She then defers to Ms. Richmond to assess the third and final listing test of whether or not there are financial factors that would make it unreasonable or inappropriate to list. The required repairs and engineering scope of works have been assessed by a QS for Daresbury and reviewed by a QS for council. Whilst there is some difference in the anticipated repair costs that we heard about before, these differences are, in my view, within a relatively narrow range of approximately 5% of the overall repair cost, being Mr. Harrison's figure of 9.7 million, including GIST for Daresbury, and Mr. Stanley's figure of 9.2, including GIST for council. So sort of $500,000 difference in the context of a $10 million, $1.5 million repairs. Yep. The cost of a new build is also assessed by Mr. Stanley for council as being between 7.2 and 11.2, excluding GST, depending on the specification. To test reasonableness, my understanding is that Ms. Richmond, in essence, simply compares the repair cost with the new build cost and considers that as they fall within a similar ballpark, that the costs are reasonable and the third listing test is passed. And I read with interest today Ms. Richmond's summary, which you won't have read yet, but in that she makes the observation that it's a big building and therefore the repair bill is also going to be large and that's not unreasonable. But again, for me, that rather misses the point of reasonableness. It's not that the repair costs are 9 million. If you had to spend 9 million and end up with a building that was worth 12 million, 15 million, that would be reasonable. If you have to spend 9 million and end up with a building that's only worth 4 million, that's not. In my view, this is the wrong comparison to determine reasonableness, the one used by Ms. Richmond.
Can you read your footnote 9?
So, yes, so simply, in my view, the days of Downton Abbey with servants' quarters in the attic are well past. And so no one wants to build a Daresbury again. It doesn't meet the market. So it's a false test to say it should be rebuilt new because no one will actually want to rebuild it new. So such an assessment, in my view, at 15, in my view, wrong test of reasonableness. I instead examine the cost of repair compared to the value of the repaired building. I secondly compare the overall cost of repairs plus land value with the property's value were it to be on-sold. In my view, these are the key considerations that any homeowner makes when considering whether or not to embark on a substantial building project. Such an assessment must necessarily rely on valuation evidence. Council has neither obtained its own valuation evidence or peer-reviewed that provided by Mr. Shoulders. So Mr. Shoulders is the only valuation evidence before you. Mr. Shoulders values the repaired building as having a value of just over 4 million, just for the house itself. This compares with a repair cost between 9.2 and 9.7. There is therefore a clear gap of 5 to 5.5 million between the cost of repair and the value of the repaired building. The end cost of the resultant project is estimated by Mr. Shoulders to be in the order of 18 million, assuming no heritage listing impacting the value of the underlying land. Mr. Shoulders identifies that the most expensive house ever sold in the history of Christchurch is 9 million. In my view, having to embark on a building project where the cost of repairs is nearly twice that of what the resultant building is worth, and where to recoup costs, the overall property would need to be sold for twice the price of the most expensive residential house ever sold in Christchurch, is clearly unreasonable. As such, the threshold for not listing is clearly established. To retain the listing does not align, therefore, with the heritage policy framework, and as such is not an efficient or effective tool in delivering heritage outcomes, which were carefully crafted as a contextual response to the realities of a major earthquake. In a nutshell.
A couple of questions. Okay. But I want to work back from the word reasonableness. I mean, there's sort of contention here as to what it is and what it isn't. And part of what you've told us is where that sits in the wider picture around considerations for listing, both contested or seemingly uncontested. So we've got, and correct me if I go off piste here, but you've got a paragraph 10, reference to the policy around what should be taken into account. You've brought that into play with the qualifiers around sufficient value, first and foremost, at least there's these things, one or other, or present. In relation to those clauses 1 and 2 in your paragraph, the only area of difference between those representing Daresbury's interests and council experts is in respect of the financial cost or the reasonableness of financial costs. Engineering, etc., others are settled matters. Yeah. Going back from that to the wider policy context, as notified, let's not set aside recommendations for possible change. Is there any other reason to bring a wider test of reasonableness into consideration of either scheduling or the possibility of change to that policy framework into Section 32 says? Now, that's quite a loaded question, and there's a lot in that. So go back to the first bit of it. Is there anything outside of what you've set out in paragraph 10 that invites a consideration of reasonableness in any other terms beyond those that are either settled or the one that isn't, which is finance?
No, it's my understanding.
Setting aside what might be considered appropriate in a reasonable, as to be reasonable or unreasonable in a financial perspective, from a Section 32 or Section 32AA, what guidance would you give us as to how we should view that test when considering the appropriateness of the package of provisions?
Yeah.
You understand where I'm going with you?
Yeah.
So I think, probably, I guess, stepping right back, Section 6 is obviously sort of protect heritage from inappropriate subdivision use. So again, it's inappropriate or unreasonable.
So you've got a judgment call around
words
that.
in some ways, they're both quite qualitative words. I think you can look at the items that the panel in PC14 did agree to delist, so sort of Blue Cottage, Portstone, which is another sort of cottage, and Harley
St James.
and St James, Church and Rickin Road. So there were four properties that were delisted through PC14 that were, the panel agreed with that. Very similar methodology, I guess, to their decision around are the repair costs well in excess of the value of the repaired building at the end of it. And Daresbury was the outlier from my reading in that PC14, which prompted the legal kind of letters to council to kind of reassess that.
Why is that relevant to us?
Well, you're just asking for sort of examples of sort of how to guide your test on reasonableness or not.
Context to PC13's provisions.
Yes. So, well, it's the same here with
Policy.
provisions.
Same policy.
Same
That's
policy.
your answer? Good, thank you. So we're dealing with the same construct, different decision making panels hearing different evidence, we come to that view on a comparative analysis.
Yeah.
Nothing else that brings a wider field of vision around reasonableness?
I don't think so.
Go on.
No, I was going to say, I've got probably a question for both of you, but what you want for a short answer, I guess.
I'll be quiet.
No, just in terms of the consistent reasonableness, when you look at it, in general terms, you could say that reasonableness should be assessed objectively. Is there a risk that we're getting, or do you say that objectiveness in this context is essentially a subjective test?
I think it's inherently a qualitative term, reasonableness or unreasonableness. So you do have to form a judgment call. It's sort of, I think it's a little bit like that sort of, person on the Chatham Omnibus, test. It's sort of, I think if you knock a couple of zeros off, if you were sort of going to do an extension to your own house, the builder says, look, Commissioner Caudle, it's going to cost you $900,000 to build this extension. And then your neighbourly sort of real estate agent says, look, your house is only going to be worth an extra $400,000 at the end of it. Would most people reasonably expect, embark on that project? And I would say that they wouldn't. And it's the same proposition. Especially in a case like this where it is a privately owned home. It's a little bit different perhaps where it's a publicly owned building. And I think in her summary statement, Ms. Richmond references Motor Vale Homestead as an example, where that's sort of council owned. So the kind of what's a reasonable economic driver, I guess, of a building owned by a entity with billions of dollars of asset behind it is perhaps different from what's the same reasonableness for a private home.
So do you consider that from a planning perspective, reasonableness is more than simply an equation?
There is a degree of context to it in terms of whether it's public or private ownership, whether there is, for instance, grant but money available to bridge that gap. I think if the gap was small, within 10-20%, I think you would say that when you're balancing that up, so cost versus benefits, sort of the public benefits, sort of retaining heritage versus the private costs. If it's a small gap, then I think you would probably lean more towards the preservation. But whether it's such a large gap, it's a really significant cost on an individual. When you weigh up that cost of benefit, and it is tricky because you weigh up sort of apples and oranges. It's heritage benefit versus exactly, which does make it challenging. And the policy direction of the plan is it's qualitative. There's not a lot of criteria around that, so it is challenging. But when I look at it sort of on balance, when the dollar gap between the repair cost and the end value cost is so large, and where to recoup it on resale, it would have to be so much more than the highest value that any house has ever sold for in Christchurch. It just becomes unreasonable.
You've answered my second one. Thank you. No questions for me.
Now I'm going to suggest something now. We're going to move on to Antonio Hall, but just given the line of questioning we've just had, I'm wondering where we could put Mr. Phillips in the hot seat. And I'll explain to you why before I just come to the evidence on that. The discussion you've just had was the one exactly that Mr. Phillips had with the panel on Blue Cottage. Where the argument there was around reasonableness. He did some expert conferencing. So if all of these, and they are all recorded in the PC14 decision, and fundamentally what we went to council with was there's an adopted methodology on Blue Cottage. What happened on Daresbury? If you take everything the panel determined on Blue Cottage, you applied that to Daresbury, they could not have come up with the answer they came up with, and that's why the council made the decision it did, like elected council made the decision it did. So I'm just wondering whether it would help, given the question.
So that's in the.
Yes, yeah, and I also wrote a similar letter to the minister.
Yes, that's also in the appendices.
So it was really we went through St James, and Mr Cleese was the planner on that. We went through Blue Cottage, which is similar because it is residential. I rewatched my cross-examination of Suzanne this morning, and there was a comparison between Portstone and Ferry Road and Blue Cottage, owned by Mr Carter on Montreal. And I asked her a question about whether it made a difference to this reasonable test, whether the owner had the money to do it or not, because the lady who owned the Ferry Road property didn't, and Mr Carter is obviously, and her answer was that it did make a difference, that Mr Carter had the money to do it, and he and I took exception to that, said that that was not the test. The test was what the reasonable landowner would do, and the fact that Mr Carter had sufficient funds to do it was irrelevant. So that's all in the link, which is still live on my cross-examination of Ms Richardson in PC14. My cross-examination of her went into the legal submissions. Mr Phillips dealt with it in detail. I think he did some expert conferencing, and that was the crux of when we went to council and said what went wrong with Daresbury when you apply the methodology you applied to Portstone, St James, Harley and Blue Cottage. How did you end up with a different answer on Daresbury?
Essentially what you've just said is inherent in your appendices paper trail, if you like. What do you want us to hear from Mr.
Just one of the questions you've just asked Mr Cleese, I'm wondering whether you would like to explore those with Mr Phillips and ask him the same questions, and he can probably be very helpful about what the IHP decided in Blue Cottage, which I think is right, and that is actually the answer that you're looking for. Because Blue Cottage, they did decide on the law, sorry, not on the facts of Blue Cottage, but on the questions you're asking were all, we say, properly resolved in relation to Blue Cottage.
I'm not inclined to.
Okay, that's fine.
That's my gut feel, because I don't know that can. Well, one, I'm troubled by questioning something on evidence I haven't received.
Oh, so I thought I'd indicate at the start I was going to call Mr Phillips for 5 minutes on Antonio.
Totally, hardly noticed when we've made directions in terms of evidence to be filed.
Well, what I can say is I wasn't acting for Antonio, and we thought we were getting a decision from the minister on Friday.
Let's hear from Mr Phillips. If we've got related questions while he's hot and bothered, we can ask him.
Yeah. Okay. And then I'll just call for 5 minutes the one witness on Antonio with the dollars. Yep.
31 Pendleton.
Mr. Brewster.
31 Pendleton Road.
Oh, sorry. 31 Pendleton. Yep.
So June 21, 5 years ago, 7.6 mil.
2021.
Yeah, 7,600,000.
Yeah.
The land area is 4,095, but about 1,000 square metres of that was under the Owen River. The boundary sort of crept into the river somehow. So in my report, my previous report, it was in the on the previous hearing, it was on there. And I used a neat land just to dry part of the site rather than the.
It's about 1,000, you say, roughly. We're talking.
Yeah, and it's been subdivided into 2 sites since redeveloped.
Okay. What can you tell us?
So I'm here at late notice in the sense that I've been assisting a party that's been looking at Antonio Hall with a view to developing it and advising them on the consenting prospects. Through that transpire that the provisions in terms of this process and the listing are obviously a major impediment to anyone looking to develop or utilise the site. The owner of the site didn't have submissions or I was in a position to file evidence, so it's sort of late notice. I think the brief position on.
Sorry, if I could just explain, we thought we were getting the decision on Friday and we're not, so it's the same reason as to why we didn't file any evidence. So
It's one of the parked decisions, yeah.
that's one of the PAC decisions,
Yeah.
yep.
So, I mean, in a nutshell, I mean, my position is concurring with Mr. Cleese's evidence, having read that in regards to Section 32 evaluations needing to consider the other part of the equation, so that your heritage values, it's the costs, benefits, efficiency, effectiveness, risk of not acting in terms of what's likely to transpire, where that sits in terms of the purpose of the Act. Because I think Antonio Hall has, in terms of my observations, many of the same circumstances as Daresbury, albeit that detail hasn't been explored in terms of the evidence around damage. Obviously, there is damage. Council would recognise that in terms of a reduced listing, and there's cost, and there's a track record of nothing happening with the site, and no likelihood, apparent likelihood, that anything will happen, given the condition of the building and the obstacles that the heritage listing poses.
The same cost equation stuff that we've heard.
Yeah.
It hasn't been done in relation.
At all or updated in relation to.
It hasn't been done by council or this
Yes,
matter.
exactly.
Yeah,
Generally,
yeah.
So to the extent that the reduced heritage listing, you've got still the full of the item and still a full listing of the setting. To the extent that it imposes constraints or barriers to development, what are the costs that imposes relative to the benefits that it offers? And that hasn't been explored from my reading, and I think the reasons that Mr. Cleese has pointed out in the context of Daresbury, those concerns secondly, Mr. Joel's evidence for the rugby union series in terms of concern about demolition policy and sort of the real world scenario. I think he refers to it in treatment of vacant and damaged buildings. I also share his views about that. So to the extent that if that listing did exist for Antonio Hall, I would share his concerns that the changes to the demolition policy make it even harder to revisit the appropriateness of that listing if someone wanted to pursue redevelopment of the site. So again, all the reasons he's put forth in his evidence, I would concur.
So that's the avoid where possible wording.
The alternative wording, or the possibilities of different wording.
Yeah, and I think he explored, the value of having some particular recognition for buildings and sites that have had long-standing, damaged, vacant buildings, clearly that don't appear to be changing. There doesn't seem to be any prospect of change, and you're in that sort of purgatory where you've got a heritage listing and rules that would create, in my view, a high risk and highly uncertain consenting path to overcome those, which basically is a barrier to anyone spending money going through a process to try and develop the site. That's my experience in the short time that I've been looking at and advising the parties that are looking at Antonio Hall. They're trying to make commercial decisions about whether to pursue the site and develop the site. And the first thing I'm saying is you've got a very long, expensive, uncertain consenting pathway ahead of you. You're going to have to spend a lot of money on experts. You're going to have to spend a lot of time to go through a consent process, high likelihood of public notification, potential appeals, and you're not going to know until the end of that process whether you've been successful or not. So do you want to take a punt? My advice would be that's a very big punt, and you're going to have a significant discounting on the site or commercial arrangements in place to embark on that journey. And I guess the feedback that I'm getting from those clients is that's not workable. So again, for a site such as the Antonio Hall that's had that long history of vacancy and lack of anything occurring, from my perspective, I don't see that changing. Speaking to the point that I think that Mr. Cleese was talking about in terms of reasonableness and prospect of repair in this situation of whether parties have the financial means to repair and reinstate a damaged heritage building, or whether they can offset the costs of doing so by developing the balance of the site and diverting profits that they might receive from that development into repair. That was explored through the PC14 hearing on Blue Cottage. First point I'd make is that for these sites where they have a heritage setting, the heritage setting framework and provisions and resource consenting poses an uncertain consenting path anyway, because that controls the type and nature of development that you can do on the balance of the site. So it's not to say you couldn't get through it, but again, it's another obstacle, cost, risk and uncertainty to actually undertaking that. And then it assumes that it's going to be motivated to develop for renewal purposes rather than profit, and that they're going to take that money and put it into repairing or reinstating a building, irrespective of whether that's actually a good commercial decision or not. The evidence in the PC14 hearing in the case of the Blue Cottage was that that's not a realistic outcome. The evidence of Mr. Carter in that case was just to basically say, I'm not going to do it. That's not, you can't tell me what to do. The panel ultimately agreed. And so then you're left with that situation of, I guess, the status quo continuing and no change, getting an improvement in terms of heritage outcomes because the damaged vacant building is going to continue and you're not getting the benefits of redevelopment. Helps.
And now I have,
Rich?
both of you. Do you both want to come or one of you?
Oh, you leave because I would have.
Yeah.
So just remind me, in the context of PC14, what we're hearing is updated evidence relative to what was already presented.
Well, I don't know what I didn't, yeah. What is probably different is what the council was had compared to what the IHP panel had, to be fair to the IHP panel. The IHP panel had not much, and I didn't act in relation to it, but the councillors, by the time they had their meeting, had whatever information that they had for that council meeting.
Traversed that a little bit this morning, was
Yeah.
busy about, how far does our reach go into background material that constitutes evidence in front of us relevant to PC13?
Well, this one has no relevance really because there's no costing, there's no information. So this one's actually probably easier because what you're getting is.
Yeah, late, yeah.
Yeah, and the only reason it's late is we thought the minister was going to give us a decision on Friday and he didn't.
Our qualified standard.
Yeah.
I think this
Yeah.
is anyone, including ourselves. So look, we'll hear it.
Okay, so who's going to talk first out of the two? You just might have to introduce yourselves because
sure.
people don't know who you are.
Slowly.
So,
Late in the hot day.
yeah, that's at least, yeah, so it's Ben Rich from Mainland Capital and Chris Scott from Mainland Capital. So we'll give you just
No,
30 seconds of context.
this is the end or the start?
That's what we want to do.
Yeah, well, we're not going there.
Yeah.
We're going to talk about where we are, not where we're going. Yeah.
Okay.
Cool. So, thank you to the panel for hearing us. Chris Scott, Mainland Capital, on behalf of the owner of Antonio House. So just setting the scene, the images in front of you is this current state of disrepair of Antonio House. It's in a state of ruins, quite frankly, following the firstly Christchurch earthquakes and then subsequent fire event. Three in total.
Three fires. And I am going to come to that because I'm not sure whether the gap between the IHP information and the councillors, there was a fire that I don't think was taken into account, but I'll come to that.
Panel.
By the panel, but certainly very much taken into account by the council.
Subsequent event to them.
I don't know it was a subsequent actual event, but certainly the information was new in terms of the councillors. Yeah.
And I think importantly also, sorry.
Can I tell a little bit more about your background and your expertise and what you're?
Oh, yeah. Just talk about yourself. Yeah.
As a firm or personally?
You.
Yeah, personally, so I am from Edinburgh originally and was educated
No,
in Edinburgh. And then
professional.
I mean, you've
You've got any qualifications?
So qualifications and what you do at the moment, really.
Yeah, so in terms of third-party professional qualifications, relate strictly to investment professionals, so an IMC certificate in investment management, and that's a certificate under the CFA Institute. And with respect to my qualifications as degree educated.
What was the last bit, sorry?
Degree educated in terms of.
In your role at the moment?
My role is is finance, development and acquisition, that mainland capital.
And then you might as well introduce yourself to and
Yep, so Ben Bridge, owner of Mainland Capital, degree, Lincoln property degree. Our business does development and investment around New Zealand. And the role here is to develop the site for the purpose of student housing.
How long have you both been in those roles?
Mainland Capital was established in 2010. Yeah, so since then, but I've been in property my whole life, as is Chris. It's worked for us the last 3 or 4 years.
Excuse me, sorry. Thank you.
And prior to the events, Antonio Hall was used for student accommodation, wasn't it, or not?
In part times, yeah, it was part of
Yeah.
seminary at one point, and then more latterly student accommodation, correct?
that's good memory. Were you there then? Okay, so I think you're just going to talk about, as I understand it, the properties on the market, and you're having to advise people on investment, whether this is a wise investment or not. Is that
Yeah,
summary of
that's
it?
right. Our approach is from the standpoint of development and delivering a student-led scheme in what is an area that's currently significantly lacking in that area. And delivering. I just point to the.
Hang on now, what are you pointing to? I just want to make sure that.
Sorry, I wasn't pointing. Sorry, just I'll
I've
make
only
you
got-
just to make you aware in the context of what's in front of you. Is
Could
that
you
from
just,
the
could
western.
you take the commissioner through those documents explaining what they are?
Yeah, so this is just an excerpt from the LIM, which is obviously council supplied. What you've got is an aerial image of the site showing the disrepair and the earthquake-prone building notice that has been issued onto the site following the earthquakes. So subsequently, with this report is also a structural engineer's report, which was done in 2013, showing the structural disrepair of the building. But for the purposes of what we're discussing today, it's just to give you an aerial image in the current state of the site.
And just to so that when I get to my submissions, I can help you. This dated
2013.
March, which was just prior to that, there was a third fire that was reported in the, so there's 3 fires, and this is after the third.
That's March 2024. And what you're looking at, buildings with no roof, was the original historic building that's been burned to the ground.
Yeah, so if you look at this from the site, looking from the western, starting at the western side, which is entirely burnt down, that was originally 1909 constructed. Moving through to the eastern side of the latest elements of the improvements constructed in 1961, you'll see the only elements of roofing or any sort of building to be seen are in the more latest improvements of 1960s and 1970s. In terms of the site, that's a bit of background on that. In terms of where we sit, we carried out months of due diligence on this site and conducted or certainly applied significant resource, time and cost to undertaking a feasibility on this site. One of the rationale or one of the approaches that we did look at was the reinstatement of the buildings in acknowledgement of its heritage or the restoration of it as it stands. Third party advice from Rhodes and Associates, our quantity surveying partner or consultant, puts the cost of repair at around 15,000 to 20,000 per square meter to do so. That should be viewed in for the
1960s building.
Yeah, that's right. For the earlier improvements, it would actually be significantly more given the brickwork involved and the more complex nature of that construction. That should be taken in context with the current development assumptions to build new of around $5,000 per square meter.
And you being your aspirations for student accommodation as opposed to any other form of residential or any other use.
Correct. Yeah.
Sorry, what was that number?
It's $5,000. 5,300 to be exact.
Just the original figure you gave when you said roads, is that the roads that was being referred to previously in relation to Daresbury?
Yeah, imagine it would be.
Yes, that's fine. Same quantity for that. Yeah.
So 15K per square meter. Okay.
Yeah.
Right, thank you. Yep.
That, and I would add that is at the optimistic range. Some of the comparable evidence to do that on other heritage restorations is been between 25 and 30,000, depending on the complexity per square meter. I would just caveat, and I suppose finish from our point of view in that our approach is representative of both the market, but also a reasonable developer in assessing the delivery of accommodation resources on this site. And clearly those sort of costings are uneconomical from a feasibility point of view.
Have you looked beyond student accommodation scenario?
Yeah, it should be noted, our student accommodation is actually not reinventing the wheel in respect of delivery or construction methodology or anything such as that. So a general housing development would be around the same level of cost, substantially, slightly less, given that we are looking to provide quite significant amenity and quite a scheme with the enhanced level of beautification and something that's quite different to what is currently on the market. We're willing and able to do that, however, clearly not with those enhanced costs.
And just finally, just explain and when they're dated, just make sure the commissioners understand when the
Yes.
dated.
So just to be clear, on this, so there was a structural assessment done in 2013 for the purposes of being an earthquake-prone building. The maximum NBS that was resulted there was 15%. Now then, the subsequent fires took place, which further compromised the building, and that is what you see today. So the pictures are from March 2024. So that is on the basis that there is a unsafe and unsanitary building notice issued on the improvements. So it was a subsequent report issued.
Yeah, just to orientate which bits are we looking at?
Yeah, absolutely. So from the top, the first photo from the left.
Your image on the first page is a really good reference point for me.
Yeah. Yeah, you can kind of get both.
It's like another one and you can.
Well, you showed, as long as I can view that, tell me on that where that is related.
So this arch was here.
Yeah.
And relates to this part of the site here.
Okay.
It's more western end of the side of the site.
Yeah.
This position here is in the middle sort of spine of the building that sits in here.
Yep. That's the same date? It's the same time frame, or are we looking at different?
What photo are you?
Sorry, this image here that you referred to.
Yes, yeah, they're all the
All
same.
March?
Correct.
Are they all March?
Yes, they are.
Yeah. Yeah, the centre roof structure.
Yeah, so that's on the eastern improvements where you see the large linear block. It's just outside the working parcel there.
That's the 1960s building.
Okay, I see there's a ridge line.
Yeah.
Yeah, right.
And then you'll also see on the picture below that is the sort of the square block just beside that.
Yeah.
Leading into that area.
Yeah.
And then on the internal portions, this is the internals of the eastern block. This would be the best that we've got on the site effectively, is these last two images of the
When I say the best, you mean the best condition?
Yeah, yeah.
So the last two images of the 60s block is the best condition building.
So where is that again?
Internally on in here, is that right?
Yes.
Somewhere in this vicinity.
Yeah.
And it should be noticed, we did do internal inspections, but there was unfortunately quite a large amount of the areas that are simply and I think that's not really wanting to would end there.
Has the council been through?
The council have not been through as of yet, as far as we're aware. They've stood at the perimeter fence and taken drone footage.
Yeah.
As I said earlier, we may very well, we'd be advised on safety and all the rest of it, but it may well be that we'd like to at least go on the site if it's possible.
Yeah, we can make that available.
You won't go inside the business.
It's probably undesirable, unnecessary.
Yeah. Yeah.
Okay. All right. Question? No?
Yeah.
Thank you.
Then, Mr. Bridge, I'm going to only allow you 2 minutes on what you'd like. No, what would you like to see on the site?
Oh, no, I just
You
thought
can
it
hand
was
it out.
of relevance to, given what we're trying to achieve here in Christchurch. One of the big drivers of the economic output for Canterbury is the university and the students. We've got a crisis of shortage of student accommodation. So the development plan for this site is to create circa 120 student housing units, but unlike a halls of residence, these are actually individually titled and owned, where there's shared amenity through the common areas. So the creation of sports facilities, cooking facilities, outdoor theatre, communal washing, etc., minimisation of car parking, maximisation of bike parking and a recognition that we're about 3 minutes walk from the rec centre at the university. So this site, which I've driven past for 20 years wondering what was going on, is probably the optimum site for a comprehensive student development, but it can't be done within the confines of the heritage listing. So that's what we are planning and keen to do. And we think at the end of the day, it's got to make money, but it's there, which is contributing to one of the issues we're facing here, which is the shortage of student accommodation in Canterbury. So this is not designed for first years. This is designed for a mixture of international students and second and third year students.
And the costs that you referred to earlier, sorry, were in relation to this schematic.
That's right.
Essentially, yeah.
So in terms of the ownership, you're saying that it'd be unit ownership, so it'd be like,
Yeah. So you effectively can sell or keep as an investment property, unit titled, and you get the footprint of your property as your title, and then a share in the common areas.
it'd be a management company that would.
Correct. Yeah. So the idea is,
Like an apartment building.
yes, a step between a university hall and a freehold freestanding flat, and which the students are getting pushed further and further out to Hornby. And we're going, hey, there's really strong demand here, and this is a fantastic use for the site, which the owner is very keen on as well. So we were, not that this is particularly relevant, but we were good to go on all aspects, from feasibility to geotech due diligence to planning, etc., with that one historic heritage listing catching us a bit by surprise. Maybe that's our naivety, but they just curtailed it, stopped it dead in its tracks.
Thank you very much. Yeah.
Thank you.
Now we're going on to what options. Shall I give them to you and you can decide how long I'm going to take? Because the other option is I give them to you now and I can get this in.
Yeah, I'm probably increasing tomorrow any more than we have to.
I'm quite happy to do them. I'm just not sure how long I can go past.
Yeah, no, we have.
Yeah.
So we've got a bit of time.
Yeah.
I can come back.
No.
I'd rather go later. I think I'd rather go later tonight.
Sorry, I've got no problem with that. I thought I thought you had a deadline and I was pushing you too hard.
Not in that respect. Pushing it tomorrow is probably the lesser, was probably the other evil.
Sorry, I had misunderstood. Yeah. There's some.
We go at a clip.
I know.
Which is probably, given what we're receiving, my thought is we just box on.
Yeah.
I'm obliged, sorry.
Are you constrained in this facility at all, other than the office? Okay.
This is in front of the building falling off.
There is a back.
Joe, for what it's worth,
You can answer if you were in.
for what it's worth, up to paragraph 19 is replicated in my legal submissions.
I think a whole lot of your legal submissions are replicated from this morning, but I have to say that Ms Davidson here was responsible for bunging these together at about 3 o'clock this afternoon, so.
Well, it would assist us if you don't necessarily repeat anything. If you're in full agreement, let's just talk about points of difference.
Okay, I don't think there are any, but I just wanted to, I'll take you through it.
I was just going to say, if they are essentially replication to paragraph 19.
Well, no, they're not a replication. I hadn't read Mr Pizzi's, so I think we're saying the same thing, but yeah, shall I just skip where I can, where I think I'm repeating Mr Pizzi, but I read Mr Pizzi's sort of at about 2 o'clock, so. Yeah.
I don't know, but I don't need to hear about up to paragraph 5.
Yeah, okay, right. So I'll do this as quickly as I can. So paragraph 8, I will actually just refer to this, that council's decision was to reject the IHP's recommendation, obviously. That letter that is attached to the evidence that I wrote to Finlay, I think it was, I don't think the council has ever saw that. So I was a little bit surprised to see.
The letter that was attached to Mr. Cleeve's
Yeah, I wrote it. No, it was not attached to Mr. Cleese's evidence. It's attached to, I think, Ms. Richmond's.
Oh, yes.
And it's a letter I wrote to Buddle Finlay.
Yes.
And I think I was told, we're not giving this to the councillors and they're not receiving any new information. So as far as I'm aware, Brent can correct me if I'm wrong, the councillors did not see that legal advice. Is that right, Brent?
That's correct, Commissioners, and the reason for that was because the legal advice for the council was that.
Was yours?
That,
Not mine.
I think the legal advice.
Yeah.
Was that it was new information, and the only things the council were able to take into account in making their decision on IHP recommendations was exactly the same information that was available to the IHP.
Yeah. So I was,
Different here.
yeah, so I was very surprised to see that attached to the council officer's report, given that I was told we're putting it in the bin and the councillors are never going to see it. So.
Well,
What you're saying,
Yeah.
because you're saying that this is different context.
Exactly.
Yeah.
we're not PC 14.
No, I understand that, but I just wanted to be aware that when whatever legal advice the council received when it made its merits decision to delist was not that. As far as I'm aware, they had not seen that. So I'm just wanting to make clear what the council did.
That's helpful because we are
Yeah.
interested to how far our reach goes.
Yeah, that's exactly why I'm explaining that. Yeah, so you can disregard my wonderfully crafted advice because the councillors certainly never saw it. And I don't know that it's relevant for your decision here because the point I was making there is you delisted St James, you delisted Blue Cottage, and you applied this in Ferry Road and Hulley, and you applied this methodology. And when you apply that methodology to Daresbury, your decision is inconsistent. So that's the relevance of it, which is not relevant here, I don't think. Unless you're going to yourselves adopt some methodology that's inconsistent with what was done there, which I would say was wrong, and which is why when Mr. Cleese was being questioned about reasonableness and how you go about that, I was suggesting you might want to have a look at how the panel went about making the decision on Blue Cottage, because I think that's right. Yeah.
I think we're with you.
Yeah. So paragraph 9, just referring you to the council resolution in relation to Daresbury. The council considered the house has been damaged to an extent which is uneconomic to repair. In relation to Antonio Hall, uses slightly different wording. It says because council considers the building is significantly compromised and the site is better placed to deliver housing given its highly accessible location. So slightly different wording there. I don't know what the advice was the councillors were given.
And it's only the resolution that's relevant really to us.
Yeah.
That's all we got.
That's exactly right. So I say the council made these merits-based recommendations through logically sound, rational decision-making supported by whatever evidence it had, and it had legal advice. That wasn't my legal advice. Is its ability to make a different merits decision to the recommendation by the IHP and the information it could take into account in reaching a different conclusion on the evidence that the IHP had received. Sorry, on the evidence the IHP received. Now, just in relation to Antonio Hall, this was the point I was coming at before about timing. In relation to Antonio Hall, the press had reported that it had suffered a fire in February 2024. I've got the press articles here. And this is just the point I was wanting to iron out about timing, because you'll recall that the evidence on PC 14 was lodged in September 2023. So this is where I was trying to explain before. So those photographs that the mainland representatives gave to you were taken post the third fire and post this press reporting. But at the time of the PC 13 evidence, this fire had not occurred.
Yeah.
So it wasn't referred, and I can't find anywhere where the panel were told that. Now, one of the council witnesses, I wasn't there all the time, they tell me differently, but it's certainly not in the written evidence, and it certainly wasn't in the evidence on the days that I was there.
It had occurred prior to the evidence being given, notwithstanding what.
It had occurred not prior to the evidence being written, but prior to the hearing. But I don't believe, from what I've been found, and I'm happy to be corrected, that the panel were told that. The council laws were certainly told that because they read the newspaper, but yeah. Yeah.
Why we win the heritage? chapters were heard on PC 14?
April 24, but the evidence was September 23. So the fire had occurred in
February or March.
February, yeah.
Yeah, okay, so we've got a sequence here that we'll now understand. Yep.
So I don't know whether the IHP knew about this or not. I cannot find it in the written evidence, and I'm not going to sit and watch every transcript of live evidence, but it certainly wasn't in the evidence on the days that I cross-examined Ms. O, Ms. Richmond, and I may stand to be corrected.
Yeah.
And I can't find any reference to well, there is no costings, so I'm not sure whether that updated information is included in what you've got or not. The information you have got on the structural state of the building and what had happened to it and hasn't, I'm not sure what date of information you have got and whether these are taken into account or not. I don't know. And it's simply because I've only just been instructed.
Yeah, I might be wrong too, but I understand it's the evidence as prepared rather than what was presented at the hearing.
Yeah, sorry. So I'm asked. I don't know what you've been given today, so I don't know whether the third fire has been taken into account.
Not sure.
Yeah. So I haven't listened, so I don't know.
You would hear this morning, but what we did say to a number of the council witnesses was that we may well have reason to have a further conversation with them tomorrow, having heard what you were going to say to us this afternoon.
And to be fair to the council, you've heard the Antonio Hall witnesses say that the council have not, as I understand it, done a site visit, and I understand that is to occur this week or next week. So as I say, I stand to be corrected because I simply don't know. I haven't acted for this party until 2 days ago. So I don't know whether the council have seen it since that fire and what has been presented to you.
Well, that might be something we can pursue with them. It's a simple question to ask.
Well, I mean, you just got to know what's been taken into account to date, and you can go and have a look for yourself too. So, yep. So just dealing, and won't read all this out, paragraphs 12. So this is the minister's decision on, well, non-decision really. So paragraph 12, on the 6th of June, the minister released his decisions on 7 of the 20. We dipped out, didn't we? So paragraph 13 has not yet made a decision on Daresbury and Hall and Pico. So it's not that he said no, he just hasn't made a decision. Now, I just wanted to point out that in that letter that the minister has written, he said, I intend to consider these recommendations once the council has decided on the zoning of these areas. So it's the underlying zones. The council may refer these decisions to me again ahead of deciding on the balance of plan change 14. Now, Mr. Pizzi, you can help me. Have you advised the panel that as I understand it, and I haven't managed to properly watch the stream of last week's meeting, the council intends to tell the minister now what the underlying zoning, can you tell me what the council's going to do?
Are you talking as if we are about the information session with the council?
Yes, and what the council is going to tell the minister now about underlying zoning and when?
Yeah, no, there's nothing to tell the commissioners about that. So the information session, commissioners, I took part in an information session with the councillors on Tuesday last week, a public information session. That wasn't a decision-making forum. And the purpose of that was to report to the council and tell them about the content of the minister's decision that had been released on the 6th of June. And in explaining the minister's decision to the councillors, staff explained the content of the letter that you see quoted on this yard here, in which the minister is saying that council may wish to now make a decision on zoning. And once it makes a decision on zoning for those sites, in the minister's view, the minister will have jurisdiction then to decide on these scheduling matters for these 2 buildings. So there was no decision. There was no decision about
Was that meeting public excluded or open?
No,
that was open.
Open. There's a live stream.
It was streamed.
So, sorry, this is all news to me. So this is generally, I don't know the answer to this. So Brent, are you not going to give him the answer to his question now? Are you going to wait until December?
give the minister the
Yeah,
answer
a
to
question, because he says, the council may refer these decisions to me again ahead of deciding on the balance. So are you going to do that, or are you going to wait until everything's done at once?
Discussions.
You can have that. I don't,
We don't.
Okay, well, I'll explain why then. If we're all agreed that there's no risk of this panel saying, well, we're not going to make a decision on the submissions in front of us because we're going to wait for the minister, this is what I'm trying to head off.
what's your advice to us on that?
Well, I'm saying you can't, but Ms Richardson seems to think that you're obliged to or can defer the decision on this and leave it to the minister. I'm saying you can't. You've got a submission in front of you asking for it, and you have to make a decision. And if we're accepted on that, I don't need to go through this.
We'll make a decision on that, but your submission to us is we must. We have, that is alive in front of us, in front of me.
You can't delay or defer these two submissions on Daresbury and Antonio. That's my submission. There's no legal ability to do that. So that's the only reason I'm making that point.
Well, that's helpful. That's.
Yeah.
But with respect to Ms Hagliano, I'm sorry for interrupting, but there's nothing in Mrs Richmond's evidence that says to this panel, you cannot make a decision.
Okay, well, if we're agreed on that, I'm happy.
Well, that's the evidence we've received.
Okay.
We haven't received that evidence. We only received the evidence that we are trusted with making a decision on the PC submission.
On the merits.
Yes.
Yeah. Thank you. I'm happy with that. Just for completeness, attached to round this off is a letter that the minister wrote to me last week, and he also thinks that you can go ahead because he is aware of the PC13 hearing process. Right at the back, he acknowledges my desire for clarity and certainty ahead of PC13. He says, well, I'm not making the decision now. And then second to last paragraph, he engages us to engage directly with the council on the implications of him not making a decision now for council's PC13. So I read that to be no suggestion that you've got to stop and wait for him.
And I was suggesting
And I was suggesting that I'm happy with that. That's, yep.
you just see it now.
No, Jerry seems to.
Oh, I did.
Yeah. Okay, well, yeah. So 19, I think we're all agreed. PC13 remains a proper process available to give effect to the relief sought and valid and live two submissions to remove the heritage listing for those two buildings. Paragraph 20, the reporting officer for PC13, Ms Richmond, has adopted the recommendations of Ms O's to retain the heritage item in settings for both properties. This is perhaps where I was confused. Ms Richmond has made these recommendations to address the scenario that the heritage item and setting are not removed from the heritage schedule by PC14. So that's why I made these submissions. So if I'm misreading her, we don't seem to have a problem. That was why I got confused.
It's just a timing thing around when the
Exactly.
was presented relative to the
Exactly. That's why I made that point.
Okay.
So paragraph 21, as we know, Mr. Pizzy's very helpful memo last week, and I thank Brent for that. I was in a hearing and he helpfully filed that memorandum. I think was helpful for everyone. So the council's position is different from its officer recommendations, but there's no dispute between council and the submitters. So with respect to, well, what do you do with the views of Ms Richmond and Ms O's, given that they don't align with the position of the elected council, and the evidence doesn't seem to be relied on by the council today, I just point out they're not submitters in their own right, and I start with the submission that the evidence should be disregarded. That's where I'm, paragraph 22. So they're not a submitter in their own right, and they're not being relied on by the party who called them. So I start with a submission that it should be disregarded. I'm going to talk about the alternative, but that's where I start.
I'm completely lost with that submission because we've received expert evidence from Ms Richmond and Ms O's in terms of their areas within their fields of expertise. But I just can't understand.
But they're not being relied on by the party who's calling them. That's just, it's in a vacuum. So
it's information. It's a 42A report information.
I'll go on to deal with that. That's my primary support.
At times when you have if you call an expert who doesn't necessarily support
I don't. I never call an expert there. Yeah. So I would withdraw that evidence if that party did not support my position. I would
Legally, we're not obliged to though, are we?
Well, that's my primary submission, but I'm going to go on to say when I didn't manage to convince you on that, what do you do with it? Because certainly through PC 14, there was some evidence presented where the party that it was being called for changed its position and that evidence was withdrawn, or the panel invited it to be withdrawn because it didn't support the party who was calling it. But anyway, I'll move on to alternatively, I say the paragraph 23.
Yeah.
Alternatively, the reporting officer's recommendation should be afforded little to no weight where there is an agreement between a submitter and council on the issue. They're not a submitter in their own right. The Section 42A report presents a differing opinion. More weight must be given to the agreement between the submitter and the council than the opinions of the reporting officer. And if I recall what Mr. Pizzi put in his memorandum, I think he is relying on the evidence that the parties have given. That's my understanding for the council's position.
Yes.
Yes, so he's relying on our evidence.
We're tasked with making a recommendation. We're not tasked with making a decision.
It doesn't make any difference to the substance or the merits of your recommendation. You're still hearing evidence. You're still hearing and assessing evidence, and this is a submission about what you do with that evidence. It's not
authority for this alternative proposition.
Well, it seems logical to me that if a party calls evidence and the evidence isn't supporting your case, then but that seems like night follows day to me.
Yeah, it depends on who your witnesses are, because if you look at one of Judge, the one that I was involved with, the main power, I think it was, and there was an argument about whether the council should call expert evidence in terms of that wasn't supporting what had essentially been agreed in with mediation. And Judge Borthwick in that one said that if we hadn't called that evidence, we wouldn't have been fulfilling our duties to the court.
Well, I understand that Mr. Pizzi isn't relying on that evidence. He's not calling it. So what is its status? I understand that is what the question I just asked him.
Okay.
That is not his evidence. His evidence is now what we've produced, as I understand it.
No, I must have misunderstood your question. So the evidence led by the council was the evidence in the 42A report. The council decision on PC 14 speaks for itself, so I'm not adding anything in relation to that council decision. However, in relation to the evidence about that your client is producing, Ms. Appleyard, about the cost of repair.
Oh, sure. Today's stuff.
On
Yeah.
that stuff.
Yeah. Sure. Well, you hadn't heard it till today. Yeah, understand that. Yeah. Well, you might want to think whether you do want to adopt it or not, having heard it. Thank you.
We'll no doubt hear about that.
Yes. Mr. Pizzi can consider what he's heard from the witnesses today and decide whether he wishes to adopt it or not.
Okay, let's move.
I just point out that in paragraph 24 too, and it's, I'm not putting too much weight on this, but if the panel reaches the view that the evidence which is not called to support the council case nevertheless has some sort of status in front of this panel, we note that whilst there are further submissions opposing the delisting of Daresbury, and I think we're going to hear from the Civic Trust, there are no further submissions opposing the delisting of Antonio Hall, so I'm just making that point. So sometimes Section 42A officers might be weighing up opposing submissions, and with Daresbury there certainly is an opposing view, but with Antonio Hall there is not. There is only the submission seeking delisting, and there was no further submission. There is, I think that's correct. As far as I'm aware, there was no further submission on that. So in this particular interest, the elected council has already deliberated and decided on the merits of scheduling the heritage items and settings, taking into account essentially the same material as in front of the commissioners today. Well, you've got some new stuff updated, yeah. But certainly in the council officers' reports, there's nothing new from them. They just continue to hold a contrary view. So I didn't see anything new from them other than new evidence saying I still say the same as I said before. In terms of there was no updated costings, no updating engineering, no updated heritage status, just simply Ms. Richmond simply has a different view on the valuation, as I understand, on the evaluation methodology. The overlap between, I'm at 26, PC 14 and 13 processes has already been overly complicated and confusing for submitters, and submitter has been adversely affected by procedural issues caused by the council, and it would be unjust, I say, when you've got the evidence you've got now, other than to give effect to the decision the elected council has already reached on the merits of delisting, when essentially you have the same material, actually you have more now, updated before the commissioners. I probably don't need to go through Mr. Cleese's and Mr. Milne, Mr. Shoulders and Mr. Harrison, and why they should be heard. So I can probably skip through this. Yes, paragraph 30. In the case of Antonio Hall, Ms. Richmond adopts the evidence of Ms. O's and Mr. Hogg. Ms. Richmond accepts that the former homestead and additions are beyond repair due to fire and earthquake damage and should be removed from the schedule. However, the engineering evidence of Mr. Hogg indicates it may be possible to repair the chapel and accommodation wing. And then she says, well, because there's no detailed engineering or cost evidence available, then continue the listing. So I say this is effectively what Mr. Cleese said in a different way. In the absence of this evidence being produced by the council itself, then there is a leap in logic that parts of the complex should remain scheduled because they meet the tests of retaining some sort of significance and being able to be repaired. But it is difficult to comprehend how that conclusion could be reached when there's no evidence that the council officer has to rely on in terms of financial factors. And no explanation has been given to us as to why, in the case of every other delisting submission sought through PC 14, council did go and obtain that evidence on costing, and then it was tested, and therefore there was evidence in which their conclusion could be supported. But here, there's none. So I say that's a leap in logic, that you can't just get to Mr. Cleese's first two bits in the test and say, well, because no one's produced any evidence, including us, therefore it should remain delisted because we haven't dealt with the issue of reasonableness. However, the conclusion was able to be met by the elected councillors on the information they had, including, as we understand it, the councillors being aware of that additional fire, seeing or being aware of the state of the property. I'll come to why that is in a minute, and that the only logical conclusion that any person could reach is that it is uneconomic to reinstate, preserve any portion of the complex, given the extent of the fire damage, the absence of insurance, and the state of disrepair, which is what anyone can ascertain that. The complex has been unoccupied since 2011, is in a serious state of disrepair, has been deemed dangerous and unsanitary by the council itself in September 2024, and the owners are not in a position to do anything to address the dangerous state of the complex until the heritage protections are removed. Then I've referred to the witness, but you've already heard from him, so I don't need to do that. So as a paragraph 34, as a matter of common sense, the commissioners are invited to visit the property, to view its state, including sorry, it wasn't last year's fire damage, was it? The last fire's damage. Sorry? 2024. 2024. Yeah. And make a decision themselves in the same manner as some of the councillors appeared to have done. I've noted that the IHP were explicitly invited to undertake a site visit of Daresbury by Mr. Milne, and they never did so. Within Tauranga Hall, there's no evidence the councillors visit, or evidence, as far as I'm aware, that they knew about the more recent fire. And here we're encouraging the panel to make those visits. And that's why, for completeness, I note that in the council's decision to remove Antonio Hall was unanimous, and I do record the reasons for the council decision, which was summarised by Councillor Tyler Harrison Hunt. He'd obviously viewed the property. To be honest, the time is now. It's been a long time coming. Even though it sits outside the Policy 3 regulations, I am able to speak on it from a position of perspective and experience within Riccarton, and that is one of the issues within the upper and central Riccarton area. Seeing a big rundown house, which is rich in colonial architecture more than 100 years ago, is no longer that. et cetera. So certainly that councillor at least was taking in information he had himself from seeing the property. It is submitted that the council has already made a decision based on the factual circumstances presented to them, and the commissioners are, able to do that here, should be not able. And that's effectively an assessment against the policy 93221 that Mr. Mix, please, took you to.
And I don't think there's a contest there.
No.
Well, sorry, there might be an interpretation of merits, but not as to whether we should or shouldn't.
Absolutely, yeah. So I may be worrying about more than I thought I needed to then. So section 37, 38 and 39 paragraphs, that's really been covered with by Mr. Cleese about the lack of a thorough section 32. And then at paragraph 40, I just dealt with scope, but I don't know if there is any scope issues. Is there any scope issues, Mr. Fizzy? I haven't been here today, so I don't know if there's any scope.
There are questions regarding scope, not in relation to these properties.
No, the council submission on these properties is that
Thank you.
the release
Oh,
notice within.
Brent, I didn't need to come. I could have just relied on you.
I thought the same thing.
So that's it.
Yeah, look, it's a lot of what you conversed here in anticipation of what might have been contested issues seemingly aren't.
Yes, and I was in a hearing yesterday, so I haven't seen Mr. Pizzi today, so I'm sorry if there's repetition, but it's good that we seem to be arriving by accident in the
There's
same.
still a decision to be taken, or couple,
Sure.
frankly, in respect of each property, but we're agreed, I think. No one's telling us from a legal perspective anyway differently around whether we should or shouldn't.
Yeah, okay, I'm happy with that.
Have I captured that? Sorry.
Yes.
Yeah.
Whether we can or can't.
Can or can't.
Mm.
We can and should.
Okay, well, Mr. Pizzi and I seem to be, on the same page, so to speak.
Can I ask what's the sort of timeline on the decision or your recommendation?
Yeah, sorry, we're under instruction, if we like, to try and produce our recommendation report by a date of late August. I think it's the 20th, in order to get that recommendation report in front of this council ahead of the election cycle.
Oh, that's handy.
Yeah, that's possibly not a fatal flaw.
Yeah.
But it's the target we're aiming for. Okay. And there's obvious reasons of convenience and all the rest of it around why that would be the case. I did explain I'm actually going overseas for 4 weeks from Friday. So we've got that issue as a panel to contend with, but we're not too troubled by that. I'm simply not. My colleagues might be, but that gives us a month effectively from my return. So yeah, I'm not hearing. We're not. We don't see that as at risk, if you like, in terms of having that deadline. It's workable. Famous last words. Don't quote me.
So that's probably I repeated what Mr. Pizzi said to you.
No, I think we sort of had them as we went through.
Okay.
We've given you a bit of license today.
No, actually, I have
You
to
appreciate that.
say also that I'm much obliged. Look, we just had assumed that we would have a decision from the minister. So Mr. Milne was reluctant to go preparing truckloads of evidence.
So this play, I understand.
And Antonio Hall I inherited in the last 48 hours. I haven't done anything about.
Where you are.
Yeah.
As I said to you, there's quite a bit newish material to digest relative to what we've already heard today, and others have had the opportunity to consider as well. So we might, we'll talk about that ourselves, but there may be some need for some circular routing here around going back to council officers or council advisors.
Mr. Pizzi will obviously want to have a look at it.
Yeah, and we've got a second track through, if you like, through the Pizzi's closing. So there's that opportunity, but I'm just. Yeah, we'll need to think about whether there's process-wise anything we need to be doing in response to what's unfolded today.
Yeah,
appreciate trying to accommodating us on this day.
And I appreciate you accommodating me as well, and the license that I've had, obviously, which
As
is
the
not.
qualifiers we made in doing so still stand. All right.
Understand.
Oh, thank you. Long day.
How far out am I? Oh, 20 minutes.
extra half hour, because we are effectively behind in the sense of the schedule tomorrow. Maybe a challenge to get through tomorrow's stuff as well.
Yes, Commissioner. And I was wondering in terms of housekeeping, whether it would be a good idea to talk now about some of the council witnesses having the opportunity to respond to what's been heard this afternoon.
Yeah.
So that we can tell them now when they're meeting in the morning. So first, to my mind, might be Mr. Gavin Stanley, who's the quantity surveyor, who you had a summary of evidence from this morning. We read it. There's been further quantity surveying evidence this afternoon.
Yeah.
So he might want to respond to what he has heard if he was watching it this afternoon.
Yeah. So
And there was a table presented in evidence as well by Mr. Harrison.
Have we provided all this electronically to you?
I provided to the panel.
Yeah, we can send it to you, Brent.
Yeah.
So in terms of the opportunity, at least he may or may not want to take it.
Yes.
I mean, we'll be in some respects guided by whether he wants to respond or not.
Yes.
Yeah.
Okay.
You want to invite that question, ask him that.
So I'll ask him that question, and if he does, I'll arrange for him to be along.
And I'll send it all to you. I'll send it all to you now so that you can send it to him. Yeah.
Wonderful.
And it may be that our thoughts around the need to question several of those witnesses who we didn't question today changes overnight in the light of what we've heard today. You know,
Give that option as well.
I don't think we haven't had an opportunity to talk about that, but we'll do. So tomorrow's more of a moving feast than
And we have passed on to those witnesses that there's a possibility you might want to hear from them tomorrow.
Are you able perhaps to ensure that they're aware of what's happened this afternoon?
Is this recorded?
Yes, but I don't know when the live is. It's live. I don't know who's watching.
Kevin and Amanda.
Oh, Kevin. Okay.
Oh, Kevin's there. And Suzanne's here, so yeah, and Amanda's there. Yeah.
So there's at least have visibility, at least.
Mr. Stanley is there.
Yeah, good.
So
Right, well, as best you can, give us some heads up in the first thing in the morning. I'm sure whether there's an interest in them commenting to us,
yes.
and we'll possibly be then in a position to consider whether we want to question them further anyway.
Thank you. And we're in your hands as to whether you want to hear from Ms. O's and Mrs. Richmond in response to matters raised.
I think we need to have a talk about that before in a position to answer that. I'd be appreciative if they could be available on notice, if you like, at some stage tomorrow. This question of whether we want to or not, then this question of who we do as to how we fit that in.
Yes.
Yeah, I haven't seen a schedule or an updated schedule for tomorrow. I'm assuming we're going to keep one.
Yeah, I wanted to see whether you wanted to include Mr. Stanley in this or not.
Catch-22 to us. Well, we don't know, and we won't know that answer. So I suggest that you just give us where you're at, and at least that's a starter for 10. Yeah.
Thank you. Thank you, Commissioner.
Thank you.